like this. All right.
Buenas tardes desde Ciudad de México. Good afternoon, everyone from Mexico City. This is the third event or fourth event of today's proceedings in Mexico Investment Arbitration Days within the context of the World Arbitration Update. And before giving the floor and introducing Anna Faris, who is our moderator, I would like to remind everyone a little bit about where the World Arbitration Update came from and why we're doing this. My name is Jose Antonio Rivas, and I'm one of the co-founders of WOW, World Arbitration Update, together with Ian Laird and many others that have contributed to this kind of dreamy enterprise. The idea behind World Arbitration Update is twofold. One is to update on issues on public international law, investment arbitration, and international commercial arbitration. And why update? Well, when perhaps 10, 15 years ago, if you were really studious, you could perhaps read the 3 or 4 awards that ICSID would render, and you read them, analyze them, and know them fairly well. Today, as you have heard, there are more than 300 ongoing cases just at ICSID, and doing that updating up enterprise on your own is not Herculean. It's simply impossible. So a few of us thought, why not trying to update on a yearly basis the international arbitration community and the public international law community on those issues that we believe are worth updating and are novel issues, and some of them are relevant old issues, and that's why we're here. That's purpose number one. Purpose number two is to try to go a little bit beyond what we call the traditional centers of international arbitration, trying to go beyond the Paris, trying to go beyond London, trying to go even beyond DC, New York, etc., and recognizing that there are wonderful counsel, arbitrators, professionals who are also in the rest of the world, including Mexico and other countries in Latin America, but also Asia, Africa, Oceania, etc. And luckily, there are individuals such as those that you have heard and the panelists who believe that this is a worthwhile project, and we're trying to both decentralize and update on issues of international arbitration, investment, commercial, and public international law. And with that, I'll stop and now move on to introducing our wonderful moderator of the big question that we have, or that the panelists will have before them, which is Is Latin America special on investment arbitration? Is there something special about Latin America that makes it peculiar? So I won't steal Adriana's thunder, but I would like to say that she is an associate at Van Bell and Bellis, and she specializes in international trade and investment law, focusing on international dispute resolution and arbitration, also specializing in international trade and investment law, focusing on international dispute resolution and arbitration. She has a bachelor's degree from where else? Universidad Autónoma de México. And she also has a master's of international law and economics, also from the World Trade Institute and the University of Bayern. Now, as part of her relevance experience, she has been for more than 6 years in Brussels at Van Bell and Bellis. She has worked also before in the Ministry of Economy in Mexico over 6 years, 3 years as a senior counsel for the General Counsel of International Trade, and 3 years as legal counsel at the representation of the Ministry of Economy to the EU in Brussels. Also, she has been in very relevant negotiations for the state of Mexico, and she has also done a few cases, several cases on investment, arbitration, and trade. And so without further ado, Adriana, you have the floor. And I'll give you this so that you can speak. Thank you.
Thank you, Jose Antonio. Well, now it's my time to welcome you. Can you hear me? Okay. It's my time to welcome you all. I hope you had a great lunch, and I know it's normally difficult to join in sessions after lunchtime, but I hope you enjoyed, and now you're ready to the next session. So before introducing the topic from today, I would like to introduce these great panelists that I have here. First, I would introduce Mateus Amoire Carreteiro. Mateus is a partner and co-head at Verano's dispute resolution practice in the Sao Paulo office. He specializes in international arbitration and complex litigation and represents clients across a number of industries, such as hospitality, technology, entertainment, human and animal health, energy, mining, telecommunications, and construction. He holds a law degree from the Universidad Presbiteriana Mackenzie and 2 Masters of Laws, one from the Columbia Law School and one from Universidad de Sao Paulo. Mateus has acted as counsel in domestic and international arbitration proceedings, administered and governed by the rules of major arbitral institutions, including, among others, the International Center for Dispute Resolution, the International Court of Arbitration of the International Chamber of Commerce, the International Center for Settlement of Investment Disputes, and the Center for Arbitrators and Mediation of the Brazil-Canada Chamber of Commerce, among others. Second, I would introduce Álvaro Galindo. Álvaro is partner at Carmillani Perez Abogados. He focuses his practice on arbitration with vast experience in international litigation, particularly in arbitration under investment treaties and contracts in strategic sectors such as energy, telecommunications, and construction. He has concentrated his activity in arbitrations involving states and state entities in Latin America. Additionally, he acts as an arbitrator in domestic and international proceedings. He holds a law degree from the Pontificia Universidad Católica del Ecuador, a Master of International Law and Economics from Georgetown University. In his capacity as Director of International Affairs and Arbitration at the Attorney General Office of the Republic of Ecuador, he represented the state in the negotiation of more than 10 international investment disputes during the consultation phase provided for in international investment treaties, and in more than 20 international arbitrations under foreign investment treaties and contracts. Previously, he served as legal consultant for the International Center for Settlement of Investment Disputes, ICSI. Currently, he's a member of the ICC International Court of Arbitration. He's an arbitrator in the most renowned arbitration centers in Ecuador and in various arbitration centers in the Latin American region. He's a member of the Committee of the Permanent Court of Arbitration, PCA, for the drafting of the amendments to the PCA arbitration rules. He was a member of the list of arbitrators of the Permanent Court of Arbitration until February 2020. He currently collaborates pro bono as a member of the Latin American Alumni Directory of Georgetown University Law Center. Sorry, one moment, because I duplicated the information here. Now, I will introduce Luis González Garcia. Luis works currently at Matrix Chambers. He practices in London, UK. He specializes in public international law, investment treaty arbitration, and international trade. He acts as counsel in international arbitrations and as an arbitrator. He holds an ELM from the University of Cambridge, a Master of Laws in European Union Law from la Universidad Carlos III de Madrid. He has a specialization diploma in areas of economic integration, also from the Universidad Carlos III de Madrid, and a law degree from Northeast Autonomous University. Before joining Matrix, Luis acted as counsel and lead counsel for Mexico in NAFTA and BIT arbitrations, and legal advisor in the negotiation of international trade and investment treaties. In addition to acting in investment and commercial arbitration, Luis routinely advises governments and business on public international law matters and aspects of international trade and negotiations in relevant disciplines, such as market access, customs, investment protection, national security, climate change, and interstate dispute resolution. Luis holds SC clearance, one of the highest level of security clearance in the UK for the purposes of working for HMG departments on highly sensitive matters, including national security. For the last 6 years, he teaches negotiation skills and trade diplomacy at the University of Aberdeen. So with this, I would proceed to introduce now the topic of this panel. Is Latin America special in terms of investment arbitration? Well, Latin America is a very interesting region in terms of ISDS. In terms of treaty practice, Latin America countries have signed around 705 investment agreements. Most of these agreements were signed after the 90s, so between 1990 and 2000. But also in the recent years, after 2010, Latin American countries start terminating their agreements. Actually, the actual number is 96 agreements have been terminated by Latin American countries. Ecuador, Venezuela, and Bolivia were leading the actions to withdraw from the ISDS system. In terms of ISDS, Latin America has faced different situations that had an impact on the ISDS system, as we know. Over the last 20 years, government regulation in Latin America have given rise to a huge wave of investment arbitration. The financial crisis in Argentina in 2001 put Argentina on top of the most frequent respondents, together with Venezuela, Peru, Mexico, and Colombia. ISDS in Mexico, for example, as a result of NAFTA, has also had an impact on ISDS interpretation. Brazil has its particular views, of course, about ISDS. So this is what we are going to talk about. This panel is about the past trends and recent trends about ISDS in Latin America and how it is framing the current ISDS system. So I will let the experts talk about this really interesting topic. I would like to ask Mateus, what is currently happening in Latin America in terms of treaty practice? As I mentioned, negotiation trends in Latin America have changed, and withdrawings are also happening. So it would be really interesting to know where are the currently trends and where do you think we are heading to?
Thank you, Adriana. Thank you for the organizers for having me. Thank you, Nikki Law, for the invitation. It was at his own risk that we are going to have a Brazilian talking about investment arbitration here in Mexico. Let's see how this can play. And the question is Latin America special in terms of investment arbitration? And the answer is yes, we are always special, right? For the bad, for the good. And when I was wondering how to explain that in Mexico, considering that I'm a Brazilian, I thought that we might start by a passion that we share in whole Latin America, but of course, Mexico and Brazil. And of course, to start the presentation, I think we can talk about something that we have a passion in common, which is basically, everybody knows. You can move, please, the slide. No, it's one before. Everybody would say football, right? Soccer. But remembering my grandmother, my grandfather, I thought about a novela latina or a Latin soap opera where we have a love-hate relationship. We have drama, right? This meme has been going for a while. It's from a Brazilian soap opera and represents how the soap opera culture is rooted in our Latin America, right? And it shows this love-hate relationship that Latin governments have with investment arbitration. Of course, you need investments to develop the countries, but at the same time, when decisions are made, and we heard this morning, right? It's impossible for a government to make decisions and please everyone, not to mention other more serious problems. The relationship's not only a loved one, but you also have the part of the hate. And then we can go to the next slide. And I'm gonna be very quick here, just show the waves that we had. Of course, it's just a matter of trying to separate first case with Argentina, 2001, from the financial crisis, then Venezuela, all expropriations, and then several other cases. And that led to, and you can move to the next slide, please, to Bolivia first with Evo Morales in 2007, Ecuador after that in 2009, and Venezuela in 2012, denouncing the exit convention and certain BITs, as if this would solve a problem, or at least consider this as a political issue, would give their people some answer to ongoing concerns. Recently, Ecuador, and I'm taking advantage of being the first one to mention, but Alvaro is the expert here and he's gonna talk about it, and you can move to the next slide. Recently, last year, Ecuador re-signed the exit convention, and it was in force again since last year. So this is part of the love-hate relationship that I started talking about. So you can change for the next slide, please. And the exit statistics shows that Latin America is special, right? We have the number of cases, and here we are talking about 22% from South America, 7% from Central America, Caribbean, and we also have Mexican case, right, in the 5% of North America. And in the next slide, considering only the statistics for last year, the numbers are even higher. So the reality is that Latin America indeed plays a very relevant role in investment arbitration. And my colleagues here will explain better. So you can move to the next slide. Because Brazil plays a very different role in that scenario. And here again, we talk about Brazilian soap operas because in the 90s or the last decades, Brazil has released several soap operas that became very famous. And at the same time, 14 BITs from 2000, and this specifically from BITs from 1994, from 1997. But out of these 14 BITs that Brazil negotiated, only 6 were actually sent for the Congress to approve. And none has been ratified by Brazil. So the life for soap operas in Brazil is a little bit easier than for BITs and investment arbitration, right? And the scenario for Brazil was that one since the 90s until more recently when, and you can move for the next slide, please. Until recently, when Brazil was receiving lots of investments for the World Cup, 2014 World Cup in Brazil. And if you remember, in 2016, Brazil would also have the Olympics. So it was a specific time where we Brazilians thought that our moment had finally arrived. Said, yes, Brazil, everybody says in Brazil that Brazil is the country of the future. At the time, said, now is the future, right? Finally, we got there. And receiving lots of investments, companies getting bigger and bigger and making investments abroad. And then the government started to think about Brazilian companies doing business abroad in other countries from Latin America and Africa especially. Of course, we all know that the car wash operation was a big hit and changed our momentum, right? I mean, it didn't last a lot of time, but we had our moment. And during that specific period, and I'm giving the context of 2014, 2016 for everybody to understand what happened, is that the government said, okay, so we need something to protect those investments, but we are not gonna have treaty, right? Everybody is criticizing and having difficulties in Latin America with all these multinationals fighting against poor countries in Latin America. So let's do something different. And they prepared something called Cooperation and Facilitation Investment Agreement. And the word agreement here is intentional, right? They are not gonna call it a treaty because it's actually the problem. And when you see this is the letter issued by the Brazilian government to justify this new moment. And we are gonna and I found interesting to bring for everybody to understand in this, it's basically 3-page letter. And all the time they talk about litigation. In the beginning, they are already talking, because I'm not sure if everybody's able to read. I don't like to read, but just to give you a better context. They start by saying excessive litigation resulting from BITs is considering to affect not only the business environment and the effort to attract investment. So litigation is affecting the effort to attract investment by developing countries, but also the state's regulatory capacity to pursue public interest needs through legitimate policies in the fields of health, environment, security, etc. Avoiding dispute is thus a better option both to attract and to maintain investments. And then in the following paragraphs, they again, if you can please go to the next slide. In the next paragraph, they talk about what's the basis for those cooperation and facilitation investment agreements, right? Risk mitigation, institutional governance, thematic agendas for investment cooperation and facilitation. And again, they start talking about tools to mitigate risks and other provisions to protect investors. And in the next paragraph, and you can please go to the next slide, again, they go to investment investor-state dispute settlement. It's the backbone of traditional BITs. The Brazilian model favors mechanisms to prevent disputes based on dialogue and bilateral consultation prior to the initiation of state-to-state arbitration procedure. And this is another mechanism, right? State-to-state arbitration procedure. Such mechanisms call for direct and continuous involvement of the above mentioned focal points and joint committee, which are in charge of previously assessing the specific queries presented by the parties. And if you remember, and if you were here in the morning, when Meg delivered her opening statement, she mentioned that investors would go to the World Bank, request assistance to negotiate with countries because they were not, of course, having the protection they wanted. And then in 1966, the ICSID was created. So the Brazilian government in 2015 got back exactly to where, in terms of international law, people were before the creation of the ICSID. And the context here is also important to remember that the government at the time was the Labor Party, and was, at the time, Dilma was the president of Brazil, but she somehow, she was there representing the actual and the current president of Brazil, Lula, who is the same person who said recently that Russia and Ukraine could resolve their problems in a bar talking to each other. They didn't need a war to resolve their problems. So when you see all of that, you understand the context where this cooperation facilitation investment agreement comes from. Then you can move to the next slide, please. You can move another one, please. So just to have in mind how those cooperation and facilitation investment agreements work. So they would have a multi-tiered system of dispute resolution. A first one with an ombudsperson or focal points each country would have. Then if it doesn't work, would go to consultations to joint committees, and then to state-to-state arbitration. This is basically what we were discussing this morning in the aids before ICSID, right? And then you can move to the next slide, please. These agreements were all signed between 2016 and only one with Peru in 2016. And if you realize exactly the countries where Brazil at the time had some companies with interest in investing, right? The African countries and some Latin America countries. At the time, it was negotiated, and this is important to remember, I already mentioned, by the Labor Party, which is basically our left party. So all the conversation ongoing at the time about investment arbitration, bringing multinationals to sue the state, and this being against sovereignty of the countries, was very popular at the time already, as we still have some arguments ongoing nowadays. And with that, and we can go to the next slide. We have the scenario of investment arbitration in Brazil. It's basically very peculiar. Does it mean that Brazil is well behind in terms of arbitration? No, actually, the market for international arbitration in Brazil is huge nowadays. We have hundreds and hundreds of ongoing arbitrations. Some of them are huge. Most of them because everybody starts to realize that the court system was broken, or at least is slow, extremely slow. So for commercial arbitration, we basically have several ongoing arbitrations, but also for arbitrations with the state or state agents with mixed capital companies or public companies or companies with participation of the state. There are several local laws regulating that. So basically the Brazilian Arbitration Act, bidding and administrative contracts law, public service concessions, and also public-private partnerships, where the state acts to assist the development of the country in several aspects. But all those arbitrations need to be public. This is a topic that we have discussed this morning. So there it's mandatory to be public. It needs to be in Portuguese. It has to follow a substantive law, so it cannot be decided by equity, and it needs to take place in Brazil. So adopting a very protective approach and conservative approach, but it is indeed a very sophisticated market for practitioners and for the government to incentivize foreign investment to come to Brazil and being part of concessions and public-private partnerships. And that being said, you have an overview of the Brazil as a very peculiar animal in this Latin America context.
Thank you, Mateus. I would like to ask before jumping into the next thing,
Oh,
the topic.
sorry, just
Yes.
let me, I forgot that I have two slides just to show. Sorry. A 15, yes, the next one. Well, that's the next one, please. Yes, and this is if you consider the scenario, the real question, and I'm sorry for interrupting you, Adriana, is how investment come to Brazil, even considering the scenario. And if you take the information from the public sources, last year Brazil was the third one receiving foreign direct investments in the world. So although not having a mechanism of protection, direct protection, the size of the market and all the scenario seems to be good enough for investors to invest in Brazil. And this is a scenario of 2021 and 2022 from the 10 top major recipients of investment. And the next one, I took the last 20 years. You can move for the next slide, please. From Brazil, Mexico, and Argentina, for instance, to see how the numbers are. The first, I'm not sure if everybody can see, but the first line is Brazil, the second one, Mexico, and the third one, Argentina. So will the scenario change based on the investments actually received in the last 20 years? Probably not, but we never know. So
Thank you.
now it's over.
Thank you. I would just like to ask if you have trends in treaty practice.
Thank you. Yes. I think what Mateus told us is very interesting in terms of treaty practice, because there is a treaty practice, not what we are used to, but it is a treaty practice from Brazil. And it's a very, I think, sophisticated and consistent treaty practice, even though many wouldn't like it because you don't give us work. But I think it's an interesting trend from Brazil, that it has been able to sign these treaties with some of its economic partners. You didn't mention Ecuador. Ecuador in 2019 signed a treaty with Brazil on the cooperation and facilitation trend that Brazil is leading. And of course, we don't see and we don't discuss this too much in these type of forums because we don't see the disputes coming out. And of course, when there is no disputes, lawyers are not too much interested in it. And but from the diplomatic negotiation point of view, I think it's very successful. Now, there is not too many big players in the world joining these type of treaties. Maybe Mexico is a good example of those, but it's more an exception than the trend. And because of the relationship between the two countries, the economic ties, and other reasons, but we don't see this agreement being signed with other big players. For Ecuador, it was easy in 2019 because, and I will address this in my presentation, Ecuador has some difficulties, to put it lightly, to sign treaties with investor-state dispute settlement provisions. And this was an easy way for the government in 2019 to sign an investment treaty without teeth, without an ISDS provision in the agreement. So we will see in the future whether Brazil is able to attract more important players to sign this type of treaties, but I think it's something that is worth looking closely.
Can we go back to the last slide?
Were you able to listen to me? Okay. Like an ice cream. We hope we wouldn't hurt ourselves. Right. Thank you.
So we can have the last slide. So I think this is interesting. I do believe that, I mean, I agree with Mateo, Latin America is special in many ways, good ways and not so good ways. But in terms of ISDS, I think the region has a number of economic, social, and political realities that makes it a fertile ground for investment claims, and including Brazil. And I think both, I mean, Spanish-speaking countries and Portuguese-speaking country, we all embrace international adjudication. What Brazil is saying, we do believe in giving the opportunity to litigate at the international level. It's just not investor-state arbitration. So you're embracing commercial arbitration with state entities, and for disputes, I suppose, discrimination claims, state to state, basically. And I think this is the difference, because the region embraces international adjudication. It has always embraced international adjudication. I looked at the, to answer this question about whether we are special or not, I looked at the cases in the 19th century, well, up to 1936, especially here from Mexico. And most of all the mixed claims commissions in the world, all the cases brought under these mixed tribunals, most of them, or half of them, at least half of them, involve Latin American countries. So even back in the 19th century, all the way to 1950s, it seems that Latin American governments do embrace international adjudication to give assurances to foreigners that we want you in the region. And the only difference, I think, with Brazil is that we do believe that to have FDI, we do need to give these assurances to investors. So sometimes I get asked in the countries, why was Mexico embracing an investment to ISDS in the USMCA negotiation? You've been bombarded with claims, and you're still joining ICSID when no one is not joining ICSID. Mexico is joining ICSID, in the region, and then embracing investment in ISDS in the USMCA when you know that most of the claims come from the US, from US investors. And I think it has to do. I think we joined Ecuador. We joined it. Maybe you will give us that answer. I think it's this perception that we do need to give these assurances to foreigners in order to get to the Brazilian big blue peak FDI. I mean, I think that's the only difference perception in Brazil. You're telling me now that no, I don't need that. I don't need to give that assurances to investors, which is quite interesting. I think that's the only difference with Brazil. Otherwise, I think we embrace international law and we embrace international education.
Thank you. Yeah, I mean, I think it's just about the different approaches. So you touched on the next topic. You said that there's the political situation in Latin America, in many different countries, new policies, different situations happening all around Latin America have impact ISDS. So I would like to ask you, what is currently happening in Latin America in terms of ISDS? Why Venezuela, Mexico, Peru, Colombia are heading the most frequent respondents list on ISDS? So it would be great if you can address that.
I'll try. What I did, I went to the facts. So I looked at the facts, and I was quite surprised. So I looked at the new cases, new claims in the last 7 years, 8 years. Peru, 22 cases. Colombia, 20 cases. Panama, 14 cases in the last 6 years, 7 years. Mexico, 20 cases. Venezuela, 22 cases. Yeah, it's quite a lot. It's quite dramatic compared to other countries. So something is going on. And so I tried to group the policies that have triggered ISDS in the region. And I think I have put them in 4 different baskets. So the first basket are those policies aimed to reverse market-oriented policies. So, for example, policies aimed to reverse reforms in the energy sector in Mexico. That would be one group. Also, in part of that group, you would have the case against Argentina in relation to those policies reversing the privatization of pension services in Argentina, for example. Then you have a second group of policies which are related to the protection of the environment or taking into account the concerns of local communities. I think it's unique in Latin America that we not only have local communities, we have indigenous communities even within small areas land, you have different communities with different interests, and that seems to be very unique. Social inequalities have historical social inequalities in the region are quite unique in Latin America, and that is, I think, the second group of policies that are triggering ISDS in the region. The third one are investments, the compliance with local law, and with them those claims that are brought because the authorities are pursuing tax investigations or any other issues involving supply assessment of royalties, for example, and then you have setting tariffs, freezing tariffs in certain sectors, and then you have the other claims which involve the judiciary. So I think in Latin America, a lot of Latin American cases involve decisions, the way the decisions of the local courts are going against investments or investors. So those are I would group them, those policies, group them as those measures triggering ISDS regions. What are the sectors? I think the big 4 sectors that are where you would see more ISDS in the last 8 years in the region. Energy sector, of course, oil and gas, hydroelectric plants. A lot of new cases are involving the hydroelectric plants, I guess Peru, Guatemala, Costa Rica. The setting of tariffs, electricity in the electricity sector, electricity transmission issues, like like I guess Colombia, windfall taxes, and contractual renegotiations. It seems to be there's a lot of investment claims involved in the renegotiation of contracts. Another sector where we see a lot of investment claims against Latin American states, mining, the mining sector, and that goes a lot with those issues of local communities being affected by mining or environmental issues. And so how does the authorities dealing with respecting the rights of investors at the same time focusing on addressing the concerns of the local community? And then the financial sector continues to be one of the big sectors where we see a lot of investment claims. It continues to be MetLife against Argentina, Zurich against Bolivia, EBA against Bolivia. These are recent cases. And then, of course, we have all the concession cancellations or termination of concessions. There are a considerable number of claims, like Uber against Colombia, especially in the tech industry. Now we see that Espírito Santo against Mexico, Telefónica against Colombia, some cases filed against Mexico as well, involving the revocation of concession contracts. So that is where we energy transition measures, climate change related measures. We haven't seen that yet. We can see some actions in Colombia towards renewable energy, but not like in Europe. And perhaps that is the trend that at the end Latin Americans would have to adjust to sustainable investments and sustainable policies, which can trigger some investment. And so that is where I think ISDS will not go away in the region.
Thank you so much. Alvaro, I would like to ask you if Ecuador, I believe, has been experiencing recently some ISDS claims. Would you like to address a little bit about that?
Sure, thank you very much, Diana. And there is some history behind the question, the current situation of Ecuador before ISDS and the new cases. So there is already been mentioned the withdrawal from some states in the Latin American region from the ICSID system that happened first with Bolivia, then with Ecuador, then with Venezuela. And Ecuador recently rejoined the ICSID convention. And there are some specifics on the politics at that point in the region, and I can refer in particular to what was happening in Ecuador at that time. There was a change of government in 2007, and before that new administration took power, a U.S. corporation brought a claim against Ecuador, Occidental, against Ecuador under the ICSID convention. And that became a very important issue in politics in Ecuador at that time. And you may remember this morning when Meg Kinnear mentioned that she was in a taxi in Hamburg, I think, and the taxi driver said, well, this system, that is putting us in such trouble in Europe. Well, in Ecuador happened that in 2006. You could take a taxi driver, and the taxi driver would say, this Occidental company that is taking us to the World Bank in the US as a state. And at some point, and this is another anecdote, I was walking on the street. I was part of the legal team representing Ecuador at that time. And some people started to scream to us, you traitors. And I said, no, we're defending Ecuador. What's going on? that was a difficult moment, to put it lightly, for the government, and in particular for Ecuador. So that was the situation. The new government came in January 2007, and in January 2008, a bunch of bilateral investment treaties were denounced. Then a new constitution came in October 2008, and that administration, before ending 10 years later in 2017, and then the last bunch of bilateral investment treaties denounced all the bilateral investment treaties that were in place at that time. In total, 27 bilateral investment treaties were denounced. So Ecuador withdrew from the exit convention, and started to withdraw from all the apparatus of investment protection. And it even introduced in the Constitution, Article 42, the provision to basically put a lock on any future government to enter into treaties with investor-state dispute settlement provisions. At least they try to, but the provision is not well drafted, so it's a matter of interpretation as well. Then, after the Correa administration, came a new administration that everyone thought was going to be just a continuation. You may remember President Lenin Moreno, and he basically moved away from the Correa previous administration, and he started to negotiate new treaties, negotiated a treaty with Brazil, and started to try to negotiate new bilateral investment treaties, and it was not very successful. And in 2021, we had a new president, the current president, Guillermo Lasso. You may have heard some news lately this week about Ecuador. We're a very interesting laboratory for international law. That's the good thing about these issues. In any event, the current administration rejoined the exit convention. The executive put together a special task committee to basically handle the whole structure, legal structure, to rejoin the exit convention. And Ecuador received a hand from exit at that time in order to make it, all the steps necessary to rejoin the exit convention. And it passed through the Constitutional Court of Ecuador. And so Ecuador is today, again, a contracting state of that particular convention. We haven't been able, as a state, to enter into new bilateral investment treaties. As I mentioned, there is an issue on the Constitution of Ecuador. The government tried to have an interpretation from the Constitutional Court, but the Constitutional Court said that this is not an issue of interpretation. You have to first go and try to sign bilateral investment treaties, and then on the case-by-case basis, we would say whether you can finally ratify or not any new treaty that is in compliance with the current constitution. So that's what the government is trying to do now. We don't know what's going to happen. We don't have a Congress at this point since a couple of days ago. And there is some discussion on whether the government will be able to join treaties that have been already signed with Costa Rica, for example. It has a chapter on investment with the ISDS dispute settlement provision. And some people say, well, now that there is no General Assembly, is the moment. Go to the Constitutional Court, make it approved, and the issue is solved. And others say, no, you have to wait to have a new Congress in order for that new Congress in some months from now to be able to examine whether Ecuador can ratify that particular treaty with a chapter on investment. So that's somehow the atmosphere at this point. We will see what happens in the near future, but we will be as we have been for the last 2 decades, an interesting laboratory for these issues. There are current claims moving forward against Ecuador. Under the ICSID convention, there was a new claim. I think, may correct me, I think it's a contract claim brought by a Chilean state-owned company under the ICSID convention. And I'm sure we will see more of those coming at some point. They're being negotiated in the basically cooling off period, but may end up in a claim brought against the state. I think there are at least 10 different proceedings moving forward against Ecuador under the administration of the PCA in sectoral cases. Many of those sitting in Santiago de Chile because of Ecuador trying to comply with what the provision of Article 42 of the Constitution says. So the strategy was, okay, let's have a seat of these arbitrations in Santiago de Chile, and those cases that are not under the ICSID convention, but under other rules, those are the courts, the Chilean courts, that will have to examine set aside cases against those awards rendered by those tribunals.
And just to finalize, I have one last question for all of you. Do you think that Latin America, the countries, and its legal background, civil law, has an impact in ISDS? What is this impact?
Before answering that question, while you were talking, I was thinking there's something also unique about Latin America, and perhaps here you can. This would be a question for you, but it seems to me that we tend not to settle disputes, investment disputes, or we have going to the civil law legal tradition, whether our legal framework prevents government officials to negotiate what could be clearly a dispute that could have been settled, just paid to the investor without going to ICS. And some sort of constraints we have had just prevents us from negotiating. No government official wants to sign a settlement agreement. So, because I've been to other regions, I've been litigating in ISDS in other countries, and we have tried to settle some disputes, negotiate with investor. And it is allowed, and ministers are keen on trying to settle disputes, or at least that's what they say. But it seems in the region we'd like to litigate. So going back to the civil laws, I don't know if it's a cultural legal tradition to just litigate. If you look at the cases before the International Court of Justice, look at how many cases are brought by Latin American states against Latin American states. We're quite active in the ICJ. Just look at Central America. I don't know how many disputes are between Nicaragua and Costa Rica, and one against the other. I mean, so many cases about the same plot of land or that line on the river. It just seems that it's for us is going to the ICJ is, yeah, why not, right? We all have had experience in litigating in international treatment. I don't know if there's just a culture of litigating that we just in other cultures, in other regions, Asia, for example, just trying to avoid litigation. In Brazil, it seems that the scheme, the procedure, it just promotes negotiation, it promotes a discussion, and it seems like civil law tradition that pushes us to just litigate the case.
Well, I think it's interesting to see the Latin American legal tradition in relation to the investor-state dispute settlement system. I would see something that had an impact and keeps having an impact until today in some countries, which is, as you know, the Calvo doctrine from this Argentinian jurist in the 19th century that had a great impact in the Latin American region, even reaching to many of our constitutions I think Mexico is one of those that relinquished that provision a few years ago in the constitution that was reformed a few years ago. And some countries introduced those type of provisions in their constitutions, in their domestic laws, in their contracts. And it was a tradition of, I think, related to the newly independent states in the 19th century, trying to separate from the countries that were, we were colonies and we were just getting our independence and putting our foot strongly in the international arena. And I think that has an impact on how we have been approaching these issues, some with more consistency, I think, as Brazil, a good example, some with less consistency, moving depending on the pendulum, on the history of those particular countries. And I think that the civil law tradition does have an impact somehow. It's more formalistic. We see that in how we litigate the cases, how we cross-examine witnesses. So all that has an impact, of course, from particular cases going from the micro to the general, how we approach this from the policies in general.
Just a very quick remark. I think that all that Luis and Alvaro said, they somehow are similar to the problems that we face also in Brazil, which just ratifies that we are all hermanos indeed. And the only difference is how the problems are resolved. There, first you have administrative proceedings in order to try to solve the problems. Then somehow, in some cases, you have court case that will adjudicate the disputes. And in several others, we don't have investment arbitration, but those similar cases go to commercial arbitration because the government participates in incentivizing the development of infrastructure projects, concession projects, and similar. And the scenario of political instability is the same. We have just seen 4 elections in a row that were won by the Brazilian Labour Party, like first 2 with Lula, and then the second and the third and fourth with Dilma. After her impeachment, we got the election of Bolsonaro from the party more to the right, and he decided, okay, let's have a privatization of Eletrobras, which is a company already with the shares traded publicly. And the government said, okay, I'm gonna share my portion of the company. And now we have Lula back to the position of president, and he just filed a lawsuit with the Supreme Court to try to reverse the privatization. Of course, in that case, it's more sophisticated because it would be somehow a reversion of the seller of the shares, but the political instability is also plays a substantial role. So different mechanism, but everywhere in Latin America, very similar problems.
Definitely. So I'm just seeing that there's 10 minutes left. So I don't know if you would like to ask a question. We received a question from our virtual auditorium. So if anyone here, yes, okay.
Well, first, excuse the lack of practice in our English, but thank you very much for sharing with us just your experience and your perspective. I know it's difficult and personally, but which is your favorite indicator to approach to the best qualified efficacy way to see the best practices in each different countries you experience this growth of the proceedings and the arbitration swift of thinking of change these old traditional paradigms you find that are a kind of obstacle. I ask specifically your favorite indicator for qualifying efficacy in the proceedings and the greatest obstacle, may I ask?
If I understood your question correctly, from my point of view, this is from my own experience as a litigator and being in my former life a civil servant for my country, is to try to keep the high-ranking officials not to give in radio talks on Saturdays, for example. That's the first evidence in an investment arbitration case used by investors. So when you have high-ranking officials talking constantly against the foreign investors who are doing such a bad behavior against the state, and what we as politics are going to do with those investors, that's not a very good idea in terms of international investment law. And that's when we as lawyers enter into the picture to try to advise those high-ranking officials. Finally, they have to make up their mind and do whatever they want because they run the states, but they have to be clear what the consequence is of their behavior. That's the first evidence in those cases. As higher the official is, the bad the evidence will be for those lawyers trying to represent the state. So when you have the opportunity to sit with those high-ranking officials, they have to be very clear that all those declarations will have an impact. In particular, with those declarations have a particular investor that is being mentioned or a particular sector in a particular setting, in a particular jurisdiction, in a particular state. So I think this is an important message, if I may call it that way. I think it's important for the government to be clear what the obligations are under these type of treaties.
Times in state-to-state arbitration, or have they not got to that level?
Never heard about it. And I also try to find how, because those treaties were signed in 2015 and 2016, right? The Cooperation Facilitation Investment Agreement. And I try on Brazilian website and with colleagues to see if someone has used the focal points and also the joint committees, and I found no statistics at all. So probably because there was a change in government right after that, and then we had the impeachment, and the other problems were more important at the time, but we have no information at all.
If I may just comment very shortly on this, I think one of the reasons for that is as well as the huge country that Brazil is in terms of its economy, not only in territory. So the partners to these treaties, they are the small ones, and Brazil is very effective in its diplomacy. So there is no need to reach out to state-to-state disputes, because Brazil, Itamaraty, has a very clear negotiation strategy, is very effective, and that may explain one of the reasons why these provisions have not been used on a state-to-state, as we did as Ecuador against the United States under the bilateral investment treaty. Barton, you were not anymore in the government at that time. I was in the government of Ecuador, and we did brought a case for interpretation that the US was able to convince the tribunal there was not a dispute, so there was not a need to go to the merits. But you see that an explanation.
Thank you for a very interesting panel. I wanted to ask Luis a question in light of your catalog of technologies and measures in the industries. And that is, as you were looking at the cases, did you form a view as to how many of the measures that were disputed arose at the national level and how many were attributed to subnational measures?
Yes, so it was interesting to see that a lot involves subnational municipal level. Right? It's a difficulty of the central government to control the actions of municipal provincial level measures by these authorities. So yeah, they tend to involve those, but a lot of those involve measures by authorities at the national level. But Escano can expand on how many claims in the 90s, in the late 1990s, and really all of them, right? All of them in the late 1990s, waste management, metal clad, all the initial first ones involved subnational metal clad, yeah. Senior. Same in Mexico.
I just want to highlight the skills of our moderator. So managing timing, right, Adriana? Was
Yes, a
mentioned
little bit
before.
more. We have like 3 more minutes, so probably one more question, and then yeah.
Well, thank you.
This is for
Thank you
Nick.
thank you to the moderator for allowing me to ask this question. The name of the panel is quite provocative, and I want to go back to the name of the panel and ask, in light of some rising numbers of investor-state arbitration cases in Europe, especially in Spain, but not only Spain, Italy, Eastern Europe, under the ECT. Do you really think that Latin America is that special? I ask whether any of you would venture to comment on making any parallels between what has been going on in Europe for the last 10 years and what has been going on in Latin America for a longer time.
Thank you, Jose Antonio. I'm currently sitting in an audit committee with the King of Spain, and I wouldn't launch myself to comment on these parallels at this point. But I will say, just to follow one of the prior panels, in a short answer, we are special. No question about that.
And yes, we're special. Another reason why we're special. Unlike European countries, when we get a wave of cases against us, we're not withdrawing towel. We withdraw the towel. The NAFTA countries got lots of claims, and instead of saying, okay, that's it with investment chapter, let's have a note of interpretation and let's continue. So the reaction of all the Latin American countries, most of them are continuing with the system and continue negotiating investment treaties despite having all these claims. And Colombia negotiated investment chapters, knowing that the region probably was surrounded by countries dealing with lots of claims, and Colombia was embracing and negotiating investment protection, just improving the elements. And what you see in Europe, they are saying, I don't like the system, let's just withdraw from the ECT. I think we're actually in a good way.
Thank you. So I think time's up, but I would like to thank everyone. And I think we have 10 minutes for a break. So please serve some coffee.
Thank you.